was we left that.
So you are no longer opposing the application.
We
that
are
is
no
the
longer
implication.
opposing.
Okay, let me record you. Defense
you,
counsel, we are no longer opposing the application for extension of time.
Yes, my lord.
Within which the claimant may file his written address.
Thank you, my lord.
Yes. So you said you have your... Do we have the claimant online now, please?
With profound humility to this honorable court, Biola Oyebanji Jr.
Yes.
Holding the brief of Hussein Tunde Oyebanji for the claimant.
Yes. In this Yinka Yusuf case?
Yes, Your Lordship.
Okay, thank you. You're holding the brief of
Hussein Tunde HT Oyebanji.
Okay.
For the claimant.
Can you do you remember you have a motion for extension of time within which to file your written address? Can you move that in time? So Mr. Makoni, can we just assume that he has moved his motion so that we can proceed, well, please?
I agree.
Yes, so I will just say order granted, application granted.
Thank you, sir.
As a copy.
Time within which the claimant may file.
Yes, my lord. My lord, Yes.
Court application granted, time within which the claimant may file his written address is hereby extended. They already filed and served. Written address is deemed as properly filed and served.
As a copy, please.
Thank you. You can move your address, Mr. Akoni.
Thank you, my lord. My lord, the defendant counterclaim and filed his written address.
Yes.
It is dated the 27th of July, 2023.
Filed when?
My lord, it was filed on the 28th July, 2023.
Okay. Yes.
My lord, upon the receipt of the claimant's final written address,
yes,
we filed a reply on point of law.
Yes.
My lord, we assume that the reply on point of law was filed today.
No, it doesn't matter.
Thank you, my lord.
It doesn't,
we filed it on the 23rd of January 2024.
Yes.
We filed it on the 23rd of January 2024.
Okay. Yeah, we deem it as properly filed today then.
Thank you, my lord. We adopt the said written final addresses as our oral written address in this matter. And we urge your lordship.
Yes.
We urge your lordship to dismiss the claimant's claim. We urge your lordship to dismiss the claimant's claim.
Yes.
Thank you, my lord. My lord, we are not going to underbreak.
Okay. But I'm aware you just said that you have a counterclaim.
Yes, we have a counterclaim. We urge your lordship to grant the counterclaim.
Thank you, Mr. Oyebanji.
Thank you, my lord. Thank you, sir.
Respectfully, we have our claimant's final written address dated 13th of
On what date?
13th October 2022.
23, you mean?
2023.
It was then filed today.
Was filed on 17th October 2023.
Yes.
We humbly urge final written as our final written on urge your lordship to grant our claims and dismiss the counterclaim of our defendant.
Thank you. Court case is adjourned to 5th of April 2024 for judgment.
We are grateful, my lord.
Thank you, sir.
We are so grateful to you, to your lordship, sir.
Yes, call the next case, please.
Yes, number 2, NICS/KD/10/2020 between Mrs. Nike Kudirat, Komina, and Swans, Nigeria Defense Academy 2, Stanbic IBTC Pension Managers. My lord, parties absent.
Yes, appearances.
Sorry, my lord. Do we have the permission to be offline?
Yes, you can, sir.
Thank you, my lord. Thank you, my lord.
Yes, with profound humility to my lord. Mohammed Abdullah is my name. I am holding the brief of O Oyerinde, and I most respectfully announce my appearance for the claimant.
Lord, we have a representative of the council of the claimant.
Representative of the claimant.
Yes,
And you are telling me that happiness, how can a personal person represent a personal person when the person is not a company? Please, can you proceed with the announcing of the appearances? M. Abdullah holding the brief of Oyerinde for the claimant. Yes. Any appearance for the defense?
With profound humility to this honorable court, Biola Oyebanji Jr. for the defendants.
Thank you. Thank you, Father. Judgment. By a complaint and statement of facts filed in this court on the 10th of August 2020, and by a further amended statement of facts filed by the leave of court on 25th of October 2023, the claimant claimed against the defendants the relief set out as follows. We have 8 of the reliefs against the first defendant as stated on the face of the judgment, and 3 reliefs against the second defendant, also as stated on the face of the judgment. As keep it, this relief, reading out those reliefs to save the time of the court. The first defendant's statement of defense was filed on the 16th of October 2020, and by leave of court, the operative amended witness deposition on oath was deemed filed on the 8th of February 2023, whilst the statement of defense of the second defendant was deemed filed on the 21st of May 2019, and the operative amended witness deposition on oath was also deemed filed on the 8th of February 2023. The claimant did not file reply to the first and second defendant's statements of defense. At the plenary trial, the claimants testified in person and called one other witness, one Olalekan Oyeride. They both adopted their witness depositions on oath, and a total of 26 documents were tendered in evidence as exhibits to further support the claimant's case. The witnesses were both subjected to cross-examination by learned counsel for the respective first and second defendants. The defendants in turn fielded two witnesses. One, Alfa Jibrin, the client service officer of the second defendant, testified as DW1, whilst the first defendant fielded a legal officer by name S.U. Zandam as DW2. Only the second defendant tendered one document in evidence in support of its case. Both witnesses of the first and second defendants were duly cross-examined by the learned counsel for the claimant. The witness of the first defendant was also duly cross-examined by learned counsel of the second defendant. Upon conclusion of plenary trial, parties filed and exchanged final addresses in the manner prescribed by the rules of this court. The first defendant's final address was deemed filed on the 2nd of May 2023, wherein our learned counsel, Ogbeni Biola Oyebanji Esquire, now SAN, formulated three issues for determination in the suit, namely, one, whether or not the action instituted by the claimant in 2000 against the first defendant for an action that arose in 2015 is not vitiated by the provisions of the Public Officers Protection Act 2004, in that the case, having been instituted the 3 months period permitted to institute the action, is statute bar and liable to be dismissed. Two, whether or not the first defendant as the employer possessed the inherent powers to suspend the claimant as part of disciplinary measures against any erring staff for misconduct. Three, whether the claimant is entitled to the various declaratory reliefs she sought from this honorable court. For the second defendant, the final address by learned counsel S.I. Huneake Esquire was deemed filed on the 25th of October 2023, wherein a sole issue was formulated as having a reason for determination in the suit, that is, I quote, whether the suit by the claimant against the second defendant is not premature and discloses a cause of having been filed before a determination of whether the claimant has retired from the first defendant's employment or not, end of quote. The claimant's final address filed on the 18th of May 2023 was also deemed filed on the 25th of October 2023, wherein our learned counsel, Olalekan Oyeride Esquire, distilled three issues as having a reason for determination in the suit, namely, one, whether provision of Public Officers Protection Act applies to this case. Two, whether claimant's indefinite suspension without pay by the first defendant was right and lawful. Three, whether the claimant is entitled to relief sought against the defendant. Upon a proper appreciation of the totality of the pleadings of the respective parties, the evidence adduced at trial, and the totality of the circumstances of this case, it is my considered view that this suit must be decided on two broad issues without prejudice to the issues severally formulated by learned counsel to the respective parties, namely, one, whether having regards to the conjunction of circumstances and events of, in this case, the indefinite suspension of the claimant by the first defendant is totally justifiable and lawful. And 2, whether the claimant has proved his case to entitle her to the claims against the first and the second defendant. I consider it pertinent to restate at the outset the general common law principles with relation to law of evidence, to the effect that it is the party in a case who asserts that has the legal duty to prove the correctness of his assertion. And in most cases, that party is the plaintiff or claimant, as the case may be. That is what is referred to as legal burden. The burden of first proving the existence or non-existence of a fact relies on the party against whom judgment of the court will be given if no evidence were produced on either side, regard being had to any presumption that may arise on the pleadings. That is what is referred to as the evidential burden. See the provisions of section 131 and 133 of the Evidence Act 2011. See also the relevant authorities of Adegoke versus ADB, University Press Limited versus I.K. Martins Nigeria Limited, citation supplied. Indisputably, and as correctly submitted by learned counsel for the first defendant, in an action for declaratory relief such as the present case, the claimant is duty-bound to prove his claim on the strength of his own case. This is essentially so because declaratory reliefs are not granted on a platter of gold. They are only granted as products of credible and cogent evidence preferred at the instance of the claimant. See the case of Colonel Nicholas Anyaru, retired, versus Mandelius Limited, 2007, 4 Supreme Court of Nigeria at 388, and Ngweke versus Okeria, 2015, Law Pavilion Electronic Law Report at 40650. As disclosed in the further amended statement of facts, the claimant was employed by the first defendant as senior nursing officer on the 30th of October 1996, and the confirmation of appointment took effect from the 31st of October 1998. Letter of offer of temporary appointment dated the 30th of October 1996, and letter of confirmation of appointment dated the 19th of January 2000 were tendered in evidence as Exhibit C1 and C2 respectively. The story as told by the claimant is that she was given official residence at 2B, Lokoja Crescent, GRA Banawan, Kaduna in 1999, and a rent of 10,000 was deducted for the duration of occupation in the said official residence. The claimants testified that an advertisement of offer of some of the federal government properties, including some of the first defendant properties, was placed in the Daily Trust newspaper of 10th of March 2008, that is Exhibit C16. And another publication was placed also in the Daily Trust newspaper of the 24th of September 2015 for invitation to bid for properties, that is Exhibit C16A. That based on the recommendation of the Commission of Inquiry for the Investigation of Federal Government Landed Property, that is Exhibit C17, the Presidential Implementation Committee, that is PIC, was set up to take inventory of offer for lease, sale, and etc. of all designated federal government properties, and that she was offered a leasehold interest in her official residence by the PIC in the sum of 6,500,000 naira. Letter of offer of leasehold interest of property at 2B Lokoja Crescent, GRA Banawa, Kaduna, and a receipt of the sum of 6,850,000 25,000 naira were admitted in evidence as Exhibit C9 and Exhibit C11 respectively. According to the claimant, she and some other offerings were intimidated by some military officers, and they were also advised not to make payments for the federal government properties that were offered. That an advertisement was issued to offerings stating a deadline for payment, and due to the intimidation and fear of further harassment from the first defendant, she entered into an agreement with a third party, CJ Grocery Trading Company Limited, to sublease her official residence. Deed of assignment between the claimant and CJ Grocery Trading Company Limited was admitted in evidence as Exhibit C10. The further testimony of the claimant is that when the first defendant got to know about the transaction with the third party, she was ordered to vacate the property, that subsequently the first defendant forcibly reclaimed the property from the third party, that personal belongings of the properties was seized, and occupation was given to some of the first defendant's officers. The claimant also testified that the third party instituted an action against the first defendant at Kaduna State High Court in suit number KDH/KAD/17/2015, that the court, in its judgment, that is Exhibit C13/C18, granted a title and the right to transfer the property to the third party, and a letter was also written by the implementation committee of the white paper to the permanent secretary of Ministry of Defense, stating that peaceful occupation be given to the lessees of the properties, that is Exhibit C12A. The claimant further testified that on the 4th of June 2015, she was issued a query, that is Exhibit C4, that she was invited to appear before the Senior Staff Disciplinary Committee on the 10th of June 2015, and that on the 3rd of July 2015, she received a letter of indefinite suspension without salary, that is Exhibit C5. According to the claimant, she is diabetic and hypertensive and has severally applied since 2016 to resign her appointment from the first defendant's employment, but her application for resignation and payment for a severance allowance was refused on the ground that a case relating to the sublease of the property was pending in court. The claimant testified further that her net salary is 216,593 naira 65 kobo, that the credit balance of her pension with the second defendant as at December 2019 was 10,932,666 naira 40 kobo. The claimant contends that the second defendant has refused to process payment of her pension and maintained that it had not received, that is the second defendant maintained that it had not received instruction from the first defendant on her employment status. Letter of first defendant to claimant on resignation of claimant's appointment, pay slip of claimant's salary for January and February 2015, pension registration certificate of claimant, statement of accounts of claimant's retirement savings account with Stanbic IBT's pension were respectively admitted in evidence in exhibits as Exhibit C6, C7, C8, and C8A. The claimant contends that she has suffered untold psychological hardship by the first defendant's action and maintained that she is no longer interested in the first defendant's employment for health reasons. One Olalekan Yeride, who claims to be a businessman, legal practitioner, and chief executive officer of CJ Grocery Trading Company Limited, testified as CW2. He testified that a search conducted by his estate agent on the property offered for sublease by CW1, that is the claimant, revealed that the claimant, duly paid for the lease of the property at 2B Lokoja Crescent, GRA Banawa, Kaduna, and that a lease agreement was entered by the company for a transfer of all our rights and interests in the property of the company. CW2 further testified that CJ Grocery Trading Company Limited suffered series of harassment and intimidation from army personnel sent by the first defendant to continuously trespass on the subleased property and eventually forcibly took over the property. That a suit was instituted by the sublessor in Kaduna State High Court in suit number KDH/KAD/17/2015, and that the court in its judgment granted all the reliefs claimed. According to CW2, he is personally aware of the victimization and the mental torturing suffered by the claimant in the hands of the officers of the first defendant, that the sublessor had often sustained the claimant's medical bills and living costs after she was placed on indefinite suspension from the service of the first defendant. Basically, the defense put forward by the first defendant is that a letter had been written to the presidency to exempt the properties of the first defendant from the properties to be monetized, that the claimant and other members of staff of the first defendant were advised from embarking on bidding for any of the staff residencies they occupied by virtue of their employment, but the claimant and some staff defied the instruction. DW2, the sole witness of the first defendant, denied that the claimant was intimidated or harassed by the officers of the first defendant and contends that the first defendant was not aware of the agreement the claimant had with a third party with regard to the property. DW2 further testified that the said property was allocated to another member of staff and the claimant was reallocated to another property, but the claimant refused to move out of the property and her belongings were thereby removed. DW2 contends further that the claimant had abandoned her duty after she tendered a letter of resignation, that her resignation was not processed because of a pending case in court, and that appeal against the judgment of the High Court and garnishing proceedings are pending in the Court of Appeal. In his testimony, the witness of the second defendant as DW1 admitted that the claimant maintains a retirement savings account with the second defendant with a credit balance of 11,895,199 naira 67 kobo as at 13th of July 2020. DW1 testified that the second defendant did not deny the claimant's access to her retirement savings, but that the claimant is required to retire or attain the age of 50, whichever is latter, and her employment with the first defendant must have been legally determined to access the funds in the account. DW1 further testified that before our application to access the retirement savings can be processed, the second defendant must obtain the claimant's letter of retirement or letter of confirmation of valid resignation from the employment of the first defendant. DW1 contends that the first defendant have no knowledge that the claimant have retired, the claimant has retired or disengaged from the employment of the first defendant, that the claimant's action against the second defendant is premature and she is thereby not entitled to any of the claims being sought against the second defendant. Claimant's retirement savings account was tendered in evidence as Exhibit D1. Now I note that an issue of jurisdiction of the court and the competency of this suit was raised by learned counsel for the first defendant in his written address that was hinged on the ground that the claimant's case is statute bad. It is settled that in order to determine whether or not a court can exercise jurisdiction over a matter, it is the facts averred in the complaint and statement of facts and the reliefs endorsed therein a note that the court is required to examine and no more. See the cases of Muyosore versus Governor of Kwara State in Guinness Nigeria Limited, Guinness Nigeria PLC versus SKA Nigeria Limited citation supplied. The principles that guide the court in determining whether an action is statute bad as well are well settled and well to known. These principles have also been adequately captured and canvassed by learned counsel in his written address. Without having to recapitulate the said principles, it suffices to restate that the overriding factor or consideration is that the essence of a limitation law is that the legal right to enforce an action is not a perpetual right, but a right generally limited by statute. As correctly submitted by learned counsel, where a statute of limitation prescribes a period within which an action should be brought, legal proceedings cannot be properly or validly instituted after the expiration of the prescribed period. Therefore, an action which is not brought within the prescribed period offends the provision of the law and thus could not give rise to a cause of action. See the case of Yari versus National Salaries, Wages and Income Commission, 2013, Law Pavilion Electronic Law Reports at 20520. See also the cases of Odubeko versus Fowler, Egboy versus NNPC, Ekeogu versus Aliri, cited by the first defendant, learned counsel. Now, as gleaned from the statement of facts, the claimant's grievance against the first defendant is that she has been on indefinite suspension, that she had tendered a letter of resignation, but that the first defendant had refused to accept her resignation and failed to pay arrears of her salaries and other entitlements. The evidence of the claimant, and as established in Exhibit C6, dated the 9th of February 2017, is that the first defendant wrote to the claimant that our request for resignation of her appointment cannot be processed until the pending case is resolved. The further testimony of the claimant is that Exhibit C13, C18 is that by Exhibit C13, C18, judgment was delivered on the 4th of October 2018 by Kaduna State High Court in suit number KDH/KAD/17/2015, confirming that leasehold interest and rights over the property in dispute had been validly transferred to the claimant, but that in spite of the judgment, the first defendant has refused and or failed to recall the claimant from suspension and has thereby refused to process a request for resignation. Being therefore aggrieved by the action of the defendants, the suit was instituted on the 19th of February 2020. The provision of Section 2 of the Act, that is the POPA, in focus is in the instant case has been given abundant interpretation in a line of decided cases to leave no one in doubt as to its correct interpretation and application. Learned counsel for first defendant has elaborately cited some of these well-known judicial authorities. It is settled and as correctly submitted by learned claimant counsel that where the nature of the complaint is of continuous damage and injury, the POPA allows actions to be filed next after the ceasing thereof, that is, after the 3 months period prescribed by the Act. It must be stressed that the damage or injury allegedly suffered by the claimant, that is, an indefinite suspension by the first defendant, has not abated or ceased, and is therefore tantamount to a continuous damage, as was held in Oludele versus Wema Bank, Asaboro and another versus Pan Ocean Oil Corporation Nigeria Limited and another, NNPC versus Nwodo. Citation supplied. I am of the respected view that the claimant's action falls within the purview of the exception of continuous damage as the alleged indefinite suspension, arrears of salaries, and entitlement is unabated. In such a situation of continuous damage or injury as alleged by the claimant, the defense that the claim is statute bad is not available to the first defendant, and I so hold.
As a please.
Having considered in depth the arguments of the parties, I will say that the academic gymnastics of the learned counsel for the first defendant on the preliminary issue raised have been adequately determined. I shall proceed to determine the main action. The task the court is to undertake is to examine the evidence on record as adduced by the claimant in order to determine whether or not the evidence has satisfied the requirements of proof imposed by provisions of Section 131 and 132 of Evidence Act 2011 as amended to substantiate the claimant's claims as endorsed in paragraph 38 of a further amended statement of facts against the defendants. Now, evidence on record is that the claimant was issued a query and was invited to appear before SSDC. A letter of suspension, Exhibit C5, was given to the claimant on the 3rd of July 2015. The reason for the suspension is stated in Exhibit C5, which contains as follows. I quote, "Please recall that you appeared before NDA Senior Staff Disciplinary Committee, SSDC, following allegation of sundry misconduct leveled against you, which touched on disrespect to constituted authority and absence from duty without leave, among others. Based on the report of the SSDC and the submission of the registry via reference A, a right to convey the commandant's approval via reference B for your suspension from duty in accordance with Section 17, paragraph 19 and 20 of the NDA Administrative Procedure 2010. The suspension is with immediate effect and without pay." End of quote. I shall remark that the allegation leveled against the claimant in the query, that is Exhibit C4, borders on the illegal sale of the property allocated to the claimant as official residence. The claimant's grievance is that the first defendant has refused to recall her from suspension, and the first defendant has also not processed or accepted a request for resignation. While answering questions under cross-examination by the second defendant's learned counsel, the claimant testified as follows, I quote, "The first defendant did not confirm that I had resigned from its service. I approached the second defendant to release my pension, but I was told to obtain my letter of resignation. Up till now, I am still on suspension as a staff of the first defendant." End of quote. See paragraphs 31 and 36 of the further amended statement of facts and Exhibit C6, letter of the first defendant on the request for resignation. Now, it is in accord with judicial decisions and business practice to suspend an officer being investigated from the place of work to permit unhindered investigation to be carried out and also to allow peace to reign at his place of work. Suspension is defined as a temporary relief of the duties of an employee for a definite or indefinite period with a view of allowing the employer conduct investigations on allegations of misconduct or any other breaches made against an employee. There are two types of suspension. One, suspension pending inquiry, and two, suspension as a punishment. Suspension pending inquiry is not a punishment per se, for if the employee is not found guilty, the suspension has to be lifted and he has to be paid to full wages for the period as if he was never suspended. On the other hand, suspension imposed on the establishment of guilt is in the nature of punishment. It can have adverse impacts on the career prospects of the employee within the organization. There are both foreign and local judicial decisions approving suspension of an employee pending the final determination of his involvement in the allegations leveled against him. See the case of Esiaga versus University of Calabar, 2004 Law Pavilion Electronic Law Report at 1109, cited by respective learned counsel for the claimant and the first defendant. See also E.M. Rahul in the book Industrial Jurisprudence, a Critical Commentary. Nexus Butterworth, New Delhi, India, 2008. The argument of learned counsel for the first defendant is that where an employee is on suspension, he or she cannot resign. And if he or she applies for resignation, it will not be allowed in that it was a preemptive action. Learned counsel submitted further that it is lawful to have suspended the claimant pending the outcome of the decision of the first defendant, as the right to suspend an employee is available to an employer in order to effect proper investigation. Inasmuch as I agree with the position of the learned counsel that an employer has a right to suspend an employee to conduct proper investigation, my candid view, however, is that discretion to suspend must be exercised with a good sense of duty. The first defendant's right to suspend its staff is provided for in Part 10, Section 3A of the 2016 Revised Regulation Governing Conditions of Service of Academic, Senior Non-Teaching, and Junior Civilian Staff of the first defendant. It provides as follows, I quote, whenever, in the opinion of the commandant, an act of misconduct which is of such a nature as not to warrant termination of appointment or dismissal has been committed by an employee, the registrar may suspend the employee for a specific period to be determined by the gravity of the offense. As provided, the right to suspend by the first defendant is not indefinite. Evidence on record via Exhibit C5 revealed that the period of suspension was not specified, but that the claimant was placed on indefinite suspension from 3rd of July 2015. Evidence on record further reveals that 2 years after being placed in suspension, the claimant made a request to resign her appointment, but the first defendant in Exhibit C6 stated that her request for resignation was not processed due to the pending case in court. It is also in evidence that the said pending case had been determined by the court in favor of the claimant, but yet the first defendant remained unwavering in its position. I should also state that Part 10, Section 3E of the 2016 Revised Regulation Governing Conditions of Service for Academic, Senior Non-Teaching, and Junior Civil Staff of the first defendant also provides that if the employee is not found guilty of any misconduct, the suspension shall be lifted forthwith, and the employee shall be reinstated with full salary, including arrears of salary. I do not think the first defendant had exercised good sense of duty to have suspended the claimant for almost 2 years, particularly when the case had been determined by the court in our favor, and also having tendered a letter of resignation. The scope of the right of an employee to suspend an the scope of the right of an employer to suspend an employee is contingent on the contract of service and all conditions of service. The action of the first defendant is not only oppressive and wicked, but unjustifiable and unlawful, and I so hold. Perhaps at this juncture, it is imperative to restate the tried position of law that a notice of resignation is effective not from the date of the letter or from the date of the purported acceptance, but from the date the letter was received by the employer or his agent. In the case of Yusuf versus Governor of Edo State, 2001, 13 Nigeria Weekly Law Report, part 731, at pages 525 to 533, the court held, I quote, "A notice of resignation of an appointment becomes effective and valid the moment it is received by the person or authority to whom it is addressed. It is not necessary for the person to whom the notice of resignation is addressed to reply that the resignation has been accepted." End of quote. The Apex Court in Arinze versus First Bank of Nigeria, 2004, 12 Nigeria Weekly Law Report, part 888, page 663, also affirmed the right of an employee to resign even during criminal proceedings initiated by the employer. See also the cases of Waek versus Oshionebo and Onokuwebiri and another versus Ibiakana and others. Citation supplied. In the present case, the claimant has absolute right to resignation, and the first defendant has no discretion to refuse to accept it, and I so hold. Therefore, the claimant is deemed to have resigned from the first defendant's employment from the date a letter of resignation was received by the first defendant. I so further hold. Having held that the resignation was effective from the date it was received by the first defendant, the pertinent question now is whether the claimant is entitled to the reliefs being sought. In Longe versus First Bank of Nigeria PLC, 2010, 6 Nigeria Weekly Law Report, part 1189 at page 1, it was held that an employee suspended with or without pay, and whether indefinitely or for a long period of time, remains an employee in service during the suspension period until the contract of employment is determined by the employer, or until a decision about such an employee is taken one way or the other. I should remark that although the claimant's letter of resignation was not tendered in evidence, the date 9th of February 2017 is deducible from Exhibit 6.6, being the date the first defendant conveyed to the claimant that a request for resignation cannot be processed until the final determination of the case pending in court. What this means is that the claimant's resignation was effective from February 2017. As a result, the period of suspension is from 3rd of July 2015 till February 2017. Now, the reliefs at paragraph 38 sub A, B, C, and E of the further amended statement of facts are declaratory. As earlier held, the indefinite suspension of the claimant by the first defendant and the refusal to process or accept a letter of resignation is unjustifiable and unlawful. The claimant is therefore entitled to declaratory reliefs as claimed in paragraphs 38A, B, C, and E, and I so hold. The claimant is also entitled to reliefs in paragraphs 38A and G, having held that the indefinite suspension is from 3rd of July 2015 till February 2017, when she tendered a letter of resignation. I so further hold. On the claims against the second defendant as contained in paragraph 38H to J of the further amended statement of facts, the claimant alleged that the second defendant has refused to process the payment of her pension funds on the ground that no official communication was received from the first defendant on the status of her employment. The defense put forward by the second defendant is that the claimant was not denied access to a retirement savings fund and tendered in evidence Exhibit D1, the statement of the claimant's retirement savings. DW1 tendered DW1 testified that the application for pension cannot be processed until the claimant's letter of retirement or letter of confirmation of valid resignation is obtained from an employer, that is, the first defendant. As correctly submitted by the second defendant, Learned Counsel, the procedure for assessing retirement savings funds as contained in Section 7 of the Pension Reforms Act 2014. It is glaring from the facts and evidence that the claims against the second defendant is premature. The first defendant admitted that the claimant's request for resignation will not be processed until the pending case in court is determined, and this is one of the reasons the present action was instituted. As it is, the claimant's claim against the second defendant is unsupported by evidence. Without further ado, the claimant's claims against the second defendant is hereby accordingly dismissed, and as so hold.
As the court pleases.
In the final analysis, I hold that the claimant's action succeeds in substantial parts. For the avoidance of doubt and abundance of clarity, the court grants the following reliefs. 1, a declaration that the claimant's indefinite suspension by the first defendant is unjustifiable and unlawful. 2, a declaration that the calculation of the claimant's terminal entitlement shall be inclusive of the period of a suspension. 3, a declaration that the refusal and or failure of the first defendant to process or accept the claimant's letter of resignation is unjustifiable. 4, a declaration that the claimant is entitled to arrears of salary from July 2015, the date of suspension, till February 2017, the date of resignation of appointment. 5, an order of payment of 4,115,279 naira 35 kobo only, being arrears of salary, an order, I'll take that all over again, an order for the first defendant to pay the sum of 4,115,279 naira 35 kobo only, being arrears of salary in the monthly sum of 216,595 naira 65 kobo from July 2015 to date of suspension, that is till February 2017, that is 19 months. The sum of 1 million naira only, being general damages for the psychological trauma and hardship resulting from the indefinite suspension, refusal of the first defendant to accept the claimant's resignation, and denial of salaries. It is hereby further ordered that the first defendant shall pay to the claimant the sum set out in 5 and 6 above within 30 days. 8, 10% interest is awarded on the judgment sum from the date of judgment until final liquidation of the judgment sum. Parties shall bear their respective costs.
As the court pleases.
Yes, that is the end of the judgments. The judgment shall be transmitted to the Kaduna Division by end of next week. Counsel may apply for whatever reason. The court will rise, please.
Well, I must oblige, Your Lordship.
I'm also obliged, my lord. As the court pleases. Oh, I forgot.